Okay, hello viewers, welcome back, and should I also say top of the morning once again to you all. So we're back on This Morning on ITV, and the next segment, like I said already, we are going to be looking at the tribunal judgment, in Osun State, regarding Oyetola and Adeleke. So first and foremost, the truth is, joy over joy in one corner, and then the other corner you have people not so joyous. And of course, to do justice to the topic, or to the focus of the day, we have in our midst Barrister Chikwado Eze. Nice to have you, Barrister.
Good morning, everyone.
And Barrister Chikwado Eze is a legal practitioner here in Abuja. And I also have with me my colleague, Eyemese Dominic.
Barrister, very good morning to have you on the program.
Thank you very much.
Yeah, so we'll begin with the let's begin with the court's judgment on that very day. At a point, I think Adeleke was so confident that even if he goes to court, if his opponent goes to court, he will still remain the governor. But were you surprised on the turning by the tribunal, that's very judgment?
Well, I would like to clarify something with respect to every legal matter.
Okay.
And for that very purpose, I will be very circumspect
Okay.
with my approach to the judgment. Every individual going to court has one thing in mind. It's either you're going to win or you're going to lose. So irrespective of how confident you are that you have a good case, anything can happen. And then in our adjudicatory system, there is something called technical justice and substantive justice. So a party may lose a case technically, but not on the substantial part of the case. And it left for the apex court, which is the Supreme Court, to determine whether the decision from the lower court to the Court of Appeal will be right.
Okay.
So at the moment, either of them, their hopes are still hanging. So irrespective of his confidence at the time they went to court, it is expected that anything could happen. And I am not surprised that the decision appeared the way it does. For me, I have my reasons, because either of them have their lapses. I've gone through the entire judgment. I've read the dissent by the Justice, Judge 1. As regard the judgment, the majority of the decision of the judgment have their own strengths. They also have their own weaknesses. The dissent on its own part has its own strengths and the weaknesses. So in my view, I will leave it open, and it's very important that every Nigerian understand that in issues of justice, emotions are not usually the case. I remember then when we were taught in the university that we deal with form and not truth. The form, if your premises are true, the conclusion is expected to be true. So the truth or falsity of a fact goes no issue. And it is immaterial that you've seen that this is a clear case. Oh, this person won this election, this person won this election. Just the result have been declared, and you're seeing this person is popular, and only for you to come out and say that this person has lost this election in court. For me, I'm not surprised, because as a lawyer, I reason. I don't pour my emotions out there. So I'm not surprised, and I can't wait to see the decision of the apex court on this matter.
But while we wait for the case to get to the Supreme Court, if you look at the reasons why that judgment was turned in favor of the former governor over voting, and said it was not in line with the Electoral Act.
Good.
Were there any discrepancy in those judgments as attained in the Electoral Act?
Okay. Sorry, Barrister, even before you, while you're responding to Dominic, also add what is really overvoting.
All right. Now, I want to clarify something before I respond to this issue. First of all, for you to comment on any case, whether there is the judgment is right or wrong. The question is, have you read the judgment yourself? Because a court cannot just come out and read a judgment and deliver a judgment. If the court, there is what is called findings of court. It is those findings of the court that culminate to the decision or to the final decision of that particular court. So if the findings of this court has been affirmed to be true, so what will be the necessary implication or the resultant effect of those findings? First of all, there was a finding and all parties were in agreement. Let me just point out one thing before I address this issue. We are talking among the reliefs sought by the parties and the issues raised in their final written address. One thing is common. Their issues were all on offers, and these issues talked about whether he was qualified. The second issue, whether he has secured the majority of lawful votes cast, and then whether the election was in compliance with the Electoral Act, that is, having complied with the substantial compliance with the rules, the law. Now, the question there is, the first one was resolved in his favor. The crux of the matter, which is whether he was actually the one who secured the majority of the lawful votes cast. And how will we determine that? The issues that were raised, the facts that emanated from each of the parties, and largely INEC, who is deemed to be the electoral umpire. So INEC has a lot to answer.
Absolutely.
As regard whether there was overvoting or not. And each party relied on, each of the parties relied on the information they got from INEC. And what was the issue? INEC, upon conclusion of the result, 11 days after the conclusion of the result, issued a report with respect to the beavers. The beavers have made part of our electoral system by virtue of the 2022 Electoral Act. And one of the reasons the beavers is very important, which is BVA, as we call it, one of the reasons it's very important is to checkmate electoral malpractices.
Especially the area of overvoting.
Especially with respect to vote. And one of the things it tried to cure is, before now, the Electoral Act 2010 has the issue of a voters list. And voters list is to accredit people who actually come to the pool to vote. Okay, if you have a voter's card, they will tick beside your name whether you're there. It's very cumbersome. It's subject to manipulation. It's subject to a lot of things. And hence, you see, thugs can easily come in there, chase people away, pick the voter and tick. But with the beavers system introduced by the Electoral Act 2022, it makes it difficult for someone to manipulate, meaning one man, one vote. Once the accreditation has been successful, what do you now do? The result or the data collected by the beavers is sent to the INEC server, and which is where the issue lies. Out of the entire local government, the petitioner identified 10 local governments they claim to have been overvoting. And they were now urging the court that if you subtract the overvoting from these areas, about 400 something polling units, if you subtract these numbers, that the petitioner should declare the winner. Meaning that the second respondent, Adeleke, did not secure the majority of the lawful votes cast in the state election. And the question is, what is overvoting?
Bang. To every layman out
there.
To
a layman. But I will answer it in a very simple and in a simple language, at least for all of us who are not lawyers to understand. Now you talk about overvoting when you say that the people who were accredited and the people who voted did not count. That after you've done the accreditation in these areas, that there were other votes that did not correspond with the report as contained by the diverse machine you issued to us. Now, INEC issued 2 reports. The first report issued to the petitioner, and that report was issued based on the order of court to produce SEM. And it was when the matter was still, when the petition has been read, and they produced SEM. And the report with respect to the back end is the recipient of whatever information that was channeled from the beavers. Now, the divergent view here is that for the beavers itself, it can function without a network. But for the back end, which is the server, it needs network to receive and to accept information.
To retrieve the information.
Exactly. So at the conclusion of every accreditation, data from the beaver is sent to the server, to INEC server. For me, I was discussing with a colleague yesterday. I said, this is a 2-factor authentication system to ensure that whatever information that is going out from this place is also corresponding with what is here. But in the present election, which is what we are talking about today, that was not the case. There were discrepancies. So the discrepancy was what the petitioner was contending, that there had been a manipulation to give the second respondent, Adeleke, declare him the winner. Whereas they produced their own report also, which is the respondents, saying, indeed, everything that happened every day, we are correct. There was no overvoting as alleged. Now, who should now be the deciding factor, the deciding person in this issue? INEC.
Yeah, that was why I wanted to ask, because you made the points which, although we've had INEC spokespersons on this program several, but nobody has ever said the DIVAS has 2 functions. Like you can actually get data without using the network while you are in the polling unit. We've not gotten that before. I'm just hearing that for the first time. So how is it possible that INEC will want to deploy a facility that you know should have a back end where you get information, you retrieve information, and then when you use it that way, you can only get it at the point of accreditation, but you cannot get it at the back end? Is that not going to cause chaos like what we are seeing now?
It is the problem actually have as far as this, even the trade, because it has a lot to also tell with respect to the forthcoming election. And I am the firm view that INEC still has a lot of work to do, because INEC on their own end must be able to ascertain what are we going to be relying on as far as election is concerned. If it is the reports or the data contained by the beavers only, then any other thing goes no issue. If there is going to be a corresponding check to confirm if the back end, because if you read the judgment, these are the core issues that the beavers, the petitioner relies solely on the beavers report issued to them by INEC. And INEC did not deny authoring that particular report, which was issued to them 11 days after the election. Now, INEC issued another report to the second respondent with respect to the same to the election. And the question is, which of the reports should we believe? INEC now said that at the time they issued the first report to the petitioner, that their system were still synchronizing. Which argument the court did not find tenable. So what do you now mean by synchronizing? Are you saying that you accredited people and you did not conclude your accreditation before the voting started? Because the first thing to be done in election is to conclude accreditation before voting starts. And if you're not accredited, you shouldn't vote. You've issued this report, which is deemed to have emanated from you. So on what basis are you not saying that there is another report and this particular thing? So they will not say that because of the network, that there is likelihood of network fluctuation, which made it impossible to transmit the data wholly from the beavers to the server. So that occasioned the discrepancy.
So
Okay.
in what you're saying in essence now is that the discrepancy now is between INEC and the petitioner, because if INEC will provide two different data, and that's what the courts use on this judgment, it means we don't have confidence in the system.
Which is what I'm saying, because it is in either of the way you are trying to adjudge it, both parties, whether APC or PDP, I am of the firm view that they shouldn't be blamed. That the person that should bear the brunt and should go back and do their work very well is INEC. Now, I will answer it in this way. If you have accredited people and they voted, and then you come out tomorrow to say that there was another report that at the time you issued this report that this particular your system was still synchronizing. You know, every evidence adduced in court, the court had the duty to choose the way to attach to any of them.
Absolutely.
And the court chose to attach more weight to the evidence, to the Beavers report issued by INEC 11 days after the election, which appeared plausible to them to be most reliable, and then discountenance the one issued during the pendency of the matter, of the petition, on the ground that maybe something could have happened in between and led them to issue this second report to correspond with what the respondent is saying, that there was no overvoting. So for me, it's the INEC trying to save their face, that you conducted an election and declared a particular person a winner, and they are telling you that there was overvoting, and then you are trying everything possible to remedy it, that there was no overvoting. Because if the system is to be genuine and to appear correct, wholly, unblemished, there couldn't be any reason why we should be getting report upon report of a system that was solely in your custody, and you have the absolute power to determine what happens there. So what do you want a petitioner to do in such circumstance, knowing that I am aggrieved that I did not win this election and I want to challenge it? You've issued me a report that on the basis of what you issued, and mind you, in the course of the trial, I did not deny authoring those reports. They only contended, the respondents only contended the dates, because the reports they were trying to contend with was issued on the 17th, whereas their evidence was based on the report issued on the report of 27th, and which was one of the areas the dissent judge said no, there were discrepancies with respect to the evidence led by a contradiction with respect to the evidence led by the petitioner, and on that ground and among other grounds, the petition was dismissed by the dissent judge. But the majority judgment said no. For me, if the dissent judge was to rely solely on that, that would amount to technical justice. For me, I don't believe that mistake as to the actual date is substantial enough to nullify whatever report that was contained, especially in view of the fact that INEC themselves did not deny authoring or issuing those reports. They admitted both the report of 17 and 27 emanated from them. They were the author. It was in their custody. They were all certified. So whatever thing that happens in between is solely on INEC. So what I'm trying now to understand, and what I'm waiting wholly to get from the apex court, is for us to know in which direction should we now be going.
That was supposed to be our next question. So
what
should we be looking at now?
So I'm as expectant as all of us here.
Yes.
Because as a lawyer, I will not be wholly confident to agree with either of the judgments, because either of them is subject to manipulation.
In what ways?
First, if after conducting an election, you say that a party decide to pick and choose areas they feel there was overvoting. You are invariably discountenancing the votes of some people.
How? Because overvoting, like you have said, is equivalent to invalid votes.
If
So, how?
if a party decide to rely on overvoting and front all their documents, and INEC decide to probably withhold any document,
Oh, that will showcase
that will showcase
truly
that there was no
there was
overvoting. It is like there is likelihood that they were going to uphold that overvoting, subtract it, and give judgment in favor of the person who said there is overvoting. What if there was indeed no overvoting? There were other factors that made it impossible for overvoting to occur.
Okay.
So meaning that if INEC can do their job very well and then we can have confidence in them, we will know at what point can we actually arrive at to say that there was overvoting or no overvoting.
So it means if INEC have to rely on the server and then do the mathematics at the end, if they're able to establish that there was no overvoting, the judgment may turn the other way.
Of course.
So now what is expected of INEC to do now as it stands now? Because the Adeleke is heading to the appeal court. So what would be INEC, how would INEC redeem its image if truly what we're saying now that there were 2 reports from INEC?
Now, as a party, you must be consistent in your position. From the trial court, the appellate court, and the appeals court.
Okay.
So, the respondents must be consistent. What the court is looking at is the reason, what the appeals court will be looking at will be the reason for this decision. And not whether the evidence led by those parties were correct or not. If the evidence led were correct, the question the appellate court will be answering is the conclusion arrived at by either the majority judgment or the dissenting judge, whether they themselves too were correct. So these facts, they were in agreement with most of those findings of fact. Both judgments were in agreement in most of the findings. So the conclusion is based on your interpretation of what you believe, because in every judgment it is your decision based on your conviction of the evidence led by each of the parties. So that will make me to say, I believe you, I don't believe you. Or I believe you, I don't believe you. So the court, the appellate court will now be able to answer, if you're able to find this. No, based on these whole issues adduced by the respondents, I believe them and not the one by the petitioner.
By the petitioner.
Knowing that INEC is going to be consistent in saying that, first of all, there was a report from them which correspond with the position of Adeleke them, that there was no overvoting. Meaning that the court may either agree with INEC that at the time they issued the first report to the petitioner, their system was still synchronizing, because there was still an argument as to whether voters list was still going to be relevant in view of the fact that the issue of network problem made it difficult for them to accredit this, so they had to now reconcile it with the voters list. But that question to me may appear lame, because the new electoral act, the 2022 electoral act, has dispensed with the voters list. So if you're going to be relying solely on the Beavers report, the question will be, which of these reports is court going to believe in?
Okay.
And if I am to also offer my own personal opinion, I would say that the proper thing, or the proper thing that should have happened, is not to declare any of the parties winner. And maybe in those areas that they have agreed that there was overvoting, the election could be declared inconclusive and maybe a rerun to be conducted. Okay.
So my major concern now is, how long will it take INEC to issue a certificate of return should, in case Oyetola gets the victory at last? And how long should or will Adeleke get to enjoy the office?
by virtue of the electoral act, he is still enjoying. Nothing is going on until the final decision. That is what is called state of execution.
Isn't there a time frame where the apex court is expected to deliver?
Within 60 days.
Oh, awesome.
Of
Within
course,
60
the appellate
days.
court will have to decide whether the judgment. So both of them, the electoral act usually, electoral cases are usually time bound,
Definitely.
and they are constitutional. So anything, in fact, this decision was declared within 180 days. So the tribunal has 180 days to decide which way.
I see.
The appellate court of appeal, has 60 days to decide whether the judgment was correct or not. Then the Supreme Court has 60 days also to decide.
Okay, so my next question would be, I am particularly certain that one of the electoral laws, right, has to do with overvoting. So if there was a really, like you have mentioned a whole lot concerning overvoting and the INEC place, you know, whether or not they were faulted. So if indeed INEC is indeed going to be seen as they were at fault, or maybe their staff, not the institution, right? Some of their staff may have contributed to overvoting because they weren't quite probably following the process during the election. What would happen? The Electoral Act should be able to punish.
No, I feel, sorry, I feel that the institution INEC has a lot of things to decide in the forthcoming election.
Okay.
A colleague mentioned something, though a layman before mentioned something, said that the legal system is this, legal system is that. Sometimes I laugh because when you look at the strength of your case, you don't look at the laws. And that's why for a layman, once you say that this thing is true, this thing is this, you think that you go to court and they will give you judgment. It doesn't work that way. Every fact must be proved. If you don't prove your case, you will lose. Even when you will be the owner of this property and you will still lose the same property.
Because you couldn't prove.
Because you couldn't prove that this particular thing belongs to you. You will see a criminal going scot-free. Why? You must prove the ingredients, the elements of the offense with which the person was charged. So, how do you prove that this is that or that is this?
By
through
evidence.
So, in every election, the only person that can give you accurate information of what happened is INEC. So, and that's why they trust. The hope is on INEC. So, and for me, I feel, and I believe, I'm still praying also that INEC should look at those weaknesses in their own system and be able to remedy it. Much as you may not expect things to be 100% wholesome, but to a large extent, you should be able to address some of these challenges so that you'll be speaking with one voice. How would you want a petitioner to feel that you gave him report and tomorrow you're saying that this one was incoherent? There is nothing like incoherent in the Electoral Act.
Barrister, I'm afraid we may have to end it here and probably continue the discussion some other time other issues on electoral act. But our
issues.
Okay, our guest is right here. Our second guest will be looking at INEC again on this program. But I believe the allegations, rather not allegations, the evidence you just said now, two different reports from the Beavers. We're going to be investigating that to find out if INEC actually had that fault in its electoral process during the Osun election to ensure that it doesn't happen again going forward, because most people will not know that the Beavers could actually capture without sending to the back end, just like you explained here. So we'll be looking at that and finding out how INEC is going to resolve that. Well, I must thank you so much for your time this morning.
Thank you so much, Barrister.
All right, we'll take a quick break, and when we return, our next guest will be joining for yet another issues on the electoral process.